Yeah. Yeah, public service announcements, boy. It is what it is. It is what it do. What up, though?
See what it will bring. Fear Yah, because everything. Yahweh loves the birds that soul. I guarantee the answer's everything. To know Yahweh,
Leave people
should be
alone.
the Hebrew thing.
Leave them alone.
Mostly prominent, like Ch1ld, because we're dominant. Yahweh's strength is greatly marketed. The beginning, because he started it. Scriptures written, with 2 ears to listen. Women, men, and children, here is the prescription. Our way of life is not a religion. Hebrew Israelites, the secret treasures hidden. We were chosen and given a mission. They could read the Torah, but not with his wisdom. Praise God, gotta praise God, praise God, gotta praise God, praise God, represent.
All right. Now, family, we just gonna go over the pamphlet real quick. You already know. Listen, for all the people that are woken up, I know it's 11 o'clock right now, but it's better late than ever. I definitely want to go over some of the pamphlets, so let's just get into it. Um, right here, we're dealing with alienated fathers and alienated mothers, mostly alienated mothers dealing with child protective services and them stealing the children. We're going to have to fight with knowledge. All right. So let's get to it. All right. Now, if any of you all have the link, you can jump in, you can discuss, you can talk about what you want to talk about. Um, this is for you. I made sure to come here and discuss what I'm handing to everyone on the street. So if you have seen me on the street, you most likely got a copy of this book. Every time I talk to someone and I get a signature, I get them to take this book that I have for them. Right here, I want to talk about 3 things today. Am I going to be too long? I don't think anyone's going to get on today, but I definitely want to discuss the things and the wickedness of the Child Protective Services stealing children. I can't even put Child Protective Services and particular certain things because they block talking about having a defense against Child Protective Services. Why can't I have a defense against Child Protective Services as my title on YouTube? I have to change it up. But as we can see here, I want to go over 3 different things in the manual. The first one being, don't sign a safety plan or stipulation. Now, let's get there. All right. Now it says don't sign a safety plan or stipulation. This is really important because this is how they steal your children without going to court. The easiest way to steal your children is to have you sign or consent to one of their programs. That's the easiest way they do it. So they con you and they smile in your face with a contract in front of you and they want you to sign your children away. Remember, Do not sign your children away. Take them to court. Make sure they come up with some evidences so that a magistrate or a judge would hand them over instead of them having you consent to their contract to take your children away. You don't want to consent to those people. Once you consent, it's over with. You have no fight. And then they're going to circle jerk and jerk you around. You did not read the fine print that this caseworker over there with Children's Services was giving you. State agent may ask for you to sign a safety plan or voluntarily agree to home visitation as a means of either keeping your children now or having them placed back in your home on a trial basis. So they said, we'll sign this plan, we'll work with you, just sign right here. Don't sign nothing with them. The purpose of these programs is to gather enough evidence, real or imagined, to build a case to take your children. This is why, you are having a safety plan. So you agree to home visitation. You agree to these people all in your business, all in your home. Remember, states only get federal money when they put your children in foster care, not when they leave them with you under a home visitation program. So they want to steal your children. They want you to sign something so it can more easily take your children away from you. All right. These plans often require parents to agree not to use corporal punishment or other legal methods of child rearing. Right here, Children's Services have you sign something saying you won't do something so they can steal your children. These people are crafty, and this is what they're trying to steal children. For a family that has been using corporal punishment, to suddenly stop creates frustration and confusion and increases the likelihood that the parent will react out of anger. Okay, so now they're telling people to do something that is legal. It's legal to do it. But Children's Services will have you sign something saying you cannot do it. And when you do something that is legal, they can take your children. These are the games they play. They want to play on your ignorance. It also sends a message to the child that he doesn't need to obey his parents to avoid a spanking because a state agent will come out and tell them they can't spank him. If the original report had to do with problems with the child's behavior and the parent use of discipline, this safety plan will create chaos. And that's what they want you to do. They want you to create chaos. They want your child to look at you. You can't do nothing. Ha ha. I'll call the state agent on you. Now the kid is calling the state. It ain't the woman calling the state. The kid is threatening you with the state. You don't sign a plan with them. All right. Another tactic is to impose restrictions that are outside parental control, such as requiring a child to do well medically, even though the child has a diagnosed condition that will prevent this. So now they want you to do stuff that's impossible. Some of the stuff that's really out of your hands, they want you to sign something saying that you had to control something that's out of your hands so they can steal your children. This is what they're doing. Okay? The child illness leaves a high probability that he will be sick. Thus, the parents have no control over compliance with the safety plan and are simply counting the days until the child is removed. So they know the child gets sick a lot. They have you sign a plan saying that your child won't get sick, and then he gets sick again, like he always gets. And now they're stealing them because you signed something with them. Don't sign any of these plans with them. They're trying to steal your child. In one case, the child was diagnosed with a brittle bone disease and had even fractured while in foster care. The parents were asked to sign, let's continue, a safety plan which required the child not to have another fracture. The chances that he would refracture were very high and totally outside the parents' control. The bone is already fractured. Okay. It's out of it. If you let the baby go outside to play and it fractures, they're going to steal the baby away from him because you signed something with them. Because you signed it with them. All right. You don't sign nothing with these people. But let's continue though. Another case, a child had a weight disorder and had gained an additional 5 pounds during a short foster care stay. the parents will ask to sign a safety plan which required the child to lose weight. So now they want you to make your child lose weight, or we're going to steal them away from you and put you on child support. If your child does not, we're going to take the child, put you on child support, and make money for the state if your child does not lose weight. The parent had been taking their child to doctor for years of no avail. Even foster care couldn't make the child lose weight. How could the parents be expected to control their child's weight when the doctor and the state had failed? So now they want to sign something that they couldn't even do, because they know you're going to fail. And then that's when they're going to steal the child. But you consenting to it. You're signing something that says, yeah, they can take my child if you don't lose no weight. You don't sign with them. In another case, the parent of a child with a seizure disorder will ask to sign a safety plan which requires the child not to have seizures. How does a parent, if a parent could control if the child not have seizures, then the child would never have seizures. Sometimes the plan is simply to have the child's grades improve. Yet this is still outside the parent's control. The parents can do everything in their power to facilitate good grades, but it's ultimately up to the child to perform. So the performance of the child will make a child get stolen. You say you better get good grades, or we're gonna have to take them with us. Oh my God. And people will sign something like that with them. All these plans will fail and the child will end up in state custody. The fact that the parents have failed one plan gives the state grounds not to offer another. Thus, they will move for permanency, termination, and adoption. Because you signed one of their dumb plans, consenting to their little trickery to steal your child. Consent to it. Safety plans are intentionally vague and therefore impossible to follow. The plan might read, parents will maintain a home appropriate. Let me get up in here. Let me get back to it. So they're intentionally vague and therefore impossible to follow. The plan might read, parents will maintain a home appropriate for children. This is subjective. You may think your home is excellent for children, but the agent might think that because you don't have safety plugs in your outlets, the home isn't appropriate. For desperate parents, the plan might seem like an easy way to get your child home or keep him home. In the long run, however, signing a safety plan could cost your child permanently. Signing something with them, don't sign nothing with them, because it's a trickery document, and we know that. Bottom line, if you're not guilty of abuse or neglect, don't tolerate unwarranted government assault, and don't settle by agreeing to services you don't need. And yes, Title 4E is a service. Title 4E is children's services. It's in the name. It's a franchise owned by a person, a different person, and not by the government. If the agency believes you are guilty of abuse or neglect, make them prove it in court. They got to prove it in court. If you don't sign nothing with them, they got to prove it in court. All right? Don't sign anything with them, and they cannot steal your child without proving it in court. All right? Okay. Now, I want to deal with another one, even though this one is very important too. I want to deal. Let me go to page 39. Let me see. Don't waive your right to a trial. All right. As I said before, I'm handing out these booklets to everyone that I talk to. They get a free one. Don't waive your right to a trial. Parents do not have constitutional rights in juvenile court. There is no right to due process or other protections, except at trial education. This is because the presiding judge in the juvenile court is supposed to make decisions in the best interest of the child as she interprets that to be. For over 40 years, no form of due process was required in juvenile courts. Attorneys weren't even allowed. So there is no due process up in these courts. You think you're getting your Fourth Amendment, you're not. In 1966, Supreme Court ruled that some due process was required in juvenile court, but not all constitutional protection. What is due process, though? That's being able to present your case, being able to defend yourself before any of this persecution. The purpose of court decision is not to require in the juvenile process all of the constitutional rights now mandatory in the criminal or even administrative process, but rather simply to require an adjudicatory hearing whose rights required by the notions of fundamental fairness and due process under the 14th Amendment. Thus, the only time parents have any due process rights is at the adjudication. Adjudication is referred to as a trial. I didn't even get due process at my trial, but we're going to continue. Due process hearing, fact-finding hearing, jurisdictional hearing, and you always have to challenge jurisdiction, etc. in various states, going under different names, making it difficult for parents to determine which hearing is as an adjudicatory hearing. Whatever the state chooses to call it, it's the hearing where the state will present evidence and witnesses to prove their claim that you abused or neglected your child, and you would present evidence and witness to the contrary. You can also cross-examine the state's witnesses. This is the only time the state is required to prove their case, and the only time the parents may present evidence in their defense. The only time is during the trial. You have to know about discovery and interrogatories before the trial. The discovery process is very important. It is also the first time you can appeal to a higher court. Even if the juvenile court finds against you, you can appeal to the state court of appeals. The appellate court is bound by the due process of law, and the appellate court judges are commanded to look into the law and interpret it exactly as written. Juvenile court judges only commanded to act in the best interest of the child, regardless of what the law may say. They are given very liberal discretion to loosely interpret the law or even ignore it if they believe it is to be in the best interest of the child. Thus, it's your best interest to get into the appellate courts at the earliest possible point. So the juvenile court is some lowlifes anyway. They all getting bribes. She said it a different way, but look, all these people are getting bribes. We got all the documentation and we show it all the time. Because the education is the only time the state is required to prove their case and the only time parents have due process rights, state agents make extreme efforts to get the parents to stipulate or waive the education. They don't want to go to trial. None of these low-life children's services workers who lodge and is trying to steal your child, they do not want to go to trial. They do not want to answer interrogatories, do discovery, get depositions, subpoena documentation, things that they don't want to do none of that because they some dirt balls. All right. The stipulations can be worked in such a way that it doesn't sound like you abuse your child. For example, it might say that your child was injured and the injury was non-accidental, but it doesn't say that you did it. Stipulation might say the child has a medical condition and the parents are unable to manage it. This means neglect. The parents can't or won't meet their child's needs. Wording doesn't matter. Signing any stipulation, regardless of wording, is an admission that you are guilty of abuse or neglect, and as such, the state was justified in removing your child. If you sign something with them, the state is justified in stealing your child. All right? It's plain as that. You sign something with them, they're going to steal your child, period. Don't sign anything. Let them prove it with evidence, but don't admit to nothing. The state only has the power to intervene when parents have abused or neglected their child, or there's a substantial risk that they will abuse or neglect their child. They don't have the power to intervene when children are sick or have medical condition, unless the parents are neglecting the child by failing to provide adequate care. Therefore, when you stipulate, which means you agree, you're saying to the state was correct to intervene, which is admitting abuse or neglect. The state is never correct to intervene. Don't sign nothing saying, oh, it's good that they came by. Don't sign nothing, period, with them. All right? The agency will often resort to extreme measures such as withholding. Visitation to extract a stipulation from parents. Some examples. In our community, CPS takes the position that a parent must acknowledge both the abuse of their children and take responsibility for the abuse before the parent can have unsupervised visits with their children. What? What? You see what type of manipulation is this? He said the first thing you must do is admit that you was wrong before you can start getting the visitation with your child. What? That's how they're gonna take the child from you. And then you're gonna sign something saying you did it. The Child Protective community is virtually united behind the concept that the parent must acknowledge responsibility for the abuse and must clarify that abuse with the child before visitation or contact can be reestablished. What? So you have to admit you was wrong before you can get your child back. They're lying. Admit you was wrong so they can keep your child. Not succumb to these terrorist attacks. It's better to forego visitation for a short time while you make your case in court than lose your child forever in a termination of parental rights proceeding. The best way to get your child home permanently is by requiring the state to prove their allegations against you in a court of law. If they fail to prove the allegations, the case is closed. The state is very aware of this fact, which is why they work so hard to get parents to waive their right to a trial. And I hate when it keeps saying the state, because these people, because CPS is not a state agency. It worked with the state. From the chief legal counsel above, therapeutic denial reduction work and eventual clarification counseling is far more effective in reducing risk than litigation. In other words, it's easier to withhold visitation and coerce parents into signing a stipulation to proceed with going to court. It's easier to trick them to sign something. All right? And that's what they're going to do to the women. That's how they steal the children. They trick them into signing something. The state knows that it's good stance of losing a trial by failing to prove conclusivity that you are jealous of the allegations. Wow, I'm read it all the way wrong. Let me read that over. In other words, it's easier to withhold visitation and coerce parents into signing a stipulation than to proceed with going to court. They'd rather have you sign something to sign your children away than go to court. The state knows they stand a good chance of losing at trial by failing to prove conclusivity that you are guilty of the allegations. They will not be able to have any type of evidence if you take them to trial. Don't sign nothing with them. If you sign a stipulation to waive your right to a trial, you are giving up your constitutional rights and can never again argue that you didn't abuse or neglect your child. This is perhaps the most important suggestion in this book. It is the most important thing in this book is don't sign anything if you want to keep your kids. If you want your kids with you, don't sign nothing with them. Make them prove it in court. Everything, whatever you sign and consent with them is going to be used against you. It is a weapon, a pride to take your child. All right. And it's going on. Let me see, 24. I think I can do one more. One more of these. Okay, yeah. Let me go to 45. do everything by court order. You should require a court order before complying with any demands the agency might make. When the agent starts saying you need to do this or that, your response might be, Mr. Government Agent, I'm happy to do all that is asked of me by the court. Do you have a court order for things you are asking? No, they don't have a court order. Don't have them low life CPS workers. Oh, you have to do this right now or else. No, where is it in the court order? Okay. The agent might say, no, I don't have a court order, but the court will require you do the things I'm asking anyway, and it will please the judge if you have them completed early. Your response to the above statement might be, oh, I'm thankful that you are trying to assist me in completing things you believe the court might require of me. I appreciate your concerns. However, I wish to follow the legal channels set in place for matters such as these. I know the court will base requirements imposed on me on specific findings of abuse or neglect. I prefer to wait for my day in court to defend the allegations made against me rather than acting as a guilty person by complying with demands put on child abusers. So they're trying to make you do things that child abusers do and telling you that this is what the court wants you to do. No, let's let the court to tell me that. Who are you? I'm confident the evidence will support my innocence, and the court will not impose conditions on me intended for child abusers. You do not need to take a child rearing class to have a psychological evaluation until it is court ordered. It shouldn't be court ordered until the court had adjudicated you guilty of abuse or neglect. Sometimes, however, courts get in the habit of ordering all parents to complete child rearing classes, psychological evaluations, and drug screens as part of the temporary orders. They believe it is an easy way of moving cases through the system more quickly. However, federal courts have held that such restrictions can't be imposed on parents without first finding that abuse or neglect did occur, and second, finding some cause that the requirements are actually needed. Even after abuse or neglect has been adjudicated, before a psychological evaluation could be ordered, there needs to be some justification for it, rather than simply ordering them for all parents. The same applies to drug screens. There must be some reason to suspect drug use and its relationship to child abuse before a drug screen can be imposed. Likewise, there needs to be some judicial finding of parental unfitness before child rearing classes can be imposed. If a judge orders these things in temporary orders in your case, you should object orally in open court while they're being ordered. Your response might be, Your Honor, we object to these requirements being imposed without judicial findings that creates a need for them. The court is so accustomed to doing everything with a rubber stamp and herding families like cattle that you need to show them that you're a little different. You're actually going to insist on compliance with the law. The judge may ignore your objection and impose the requirement anyway. If this happens, you should file an appeal in the State Court of Appeals. Contact your legal department for assistance in finding case law for the appeal. If you are in an open court when the orders were made, but they are provided to you later, you'll need to file a motion to reconsider with the court action to remove the restrictions imposed before you appeal. In other words, you need to give the judge an opportunity to voluntarily rescind the orders before going to appeal court. Sometimes it may be your advantage to voluntarily complete some things outside of a court order. If this is the case, it should be done completely on your own because you want or need to, and without advice or assistance of a state agent. Here goes a motion to reconsider. And a motion is easy to do. I can show you a motion real quick. Let me see. Let's just do a motion. Okay. Well, it's one of my motions right here. Motion to set aside right here. I got the court right here in the top. All right. Got I got the case number right there with the motion, right? Just say what you want. I show clear psychological report from a doctor showing the maternal grandmother is a psychological abuser and been doing so for decades, and it was ignored. My information is a notarized affidavit. If the information is not correct, I will be in danger of perjury. But of course, none of my evidence is ever considered in this court. I know this is going to be ignored, but now I provided my new mailing address. I would love to have a response to this motion so I can get to a higher court. Right here, this is an easy motion to set aside magistrate decision. You can do a motion all day. But this is a motion right here. Simple, not hard. Used as a template. An example of the state is alleging that you were high at the time the children were taken. You may want to rush to the hospital for a drug screen to prove you weren't. Or the allegation might be that you were often stoned and leave the child to fend for himself. In this case, you might choose to get a drug evaluation or offer as evidence in your defense. There might be an allegation that you are mentally unstable because your mother committed suicide or some other reason. You could choose to get a psychological evaluation to combat these accusations. If you have an evaluation or take child rearing classes, either by the court order or by choice, choose your own therapist. Do not go to the person the state agent recommends. When interviewing therapists or counselors, ask them if they contract with the state. If they do, go elsewhere. If you have reason to distrust the state, it doesn't make much sense to trust those that do business with the state. All right. So, and that's a real big thing. People talk about getting therapists. It is a good thing to get a therapist, but if they contract with the state, don't deal with them. When choosing a therapist or counselor, question them closely to make certain they share and respect your closely held convictions. All right. If you are a Christian, choose a Christian counselor or enroll in a Christian-based child rearing class. If you're a vegetarian, choose a counselor that will respect your choice you've made for your family. If you are homeschooled, choose a counselor that understands and respects homeschooling. Do not sign a release of information for a state agent to speak with your therapist or obtain records. Don't ever sign a release of information with Children's Services. They can get all your information and use it against you. If you're going voluntarily prior to a finding of abuse or neglect, you'll bring the information to the court with you and use in your defense. There's no reason for the state agent to have it unless they have a court order. If the agent has a court order for the information, it should be limited to the diagnosis or findings, not the entire file. The agent should not get a court order for the information prior to adjudication of abuse or neglect. If such an order has been made, you want to file a motion to reconsider or an appeal. Be sure to get a clear order for visitation and not something like parents will get a regular visits. The order should outline exactly how often visits should occur and what type of restrictions should be imposed on them. If you don't have a clear order for visitation or anything else, you can file a motion to clarify with the court. The example is on page 50. Summary: before you do anything, require a court order. If you want something to seek a court order. If the state fails to comply with any court order, you can file a motion to show cause, to hold the agency in contempt of court. If you agree or disagree with the order, file a motion to reconsider or an appeal. Okay. And this is what I would say. Anybody who got this at a bad time, I want to apologize to you, but I definitely want to do this because I kind of told people I was going to do this, and I was late. So I want to apologize to those people. Anybody who do not want the communications, please just send a stop to the email or the text message you receive, and it will stop. And I want to thank you all. All right. And one more thing I want to show you all. Go back to it. Okay. Let me just. I'm just showing right here what I need help with. Now, do not get me wrong. When I go on the street, I ask you all to do this, sign my petition, all right? But I can give you one of these, and we can discuss compensation, or how, if you just want to help me get signatures. It is due on the 21st of next month. I have a lot of signatures. Okay. Let me get up here real quick. Okay. All right. So I have, I have many signatures, but I need 500. I need 500. All right. Now, if you all can help me, please contact me. It's good if you text me. Let me know you can help me. We can discuss anything you would like to discuss. I also have my public relation manager you can get in contact with. But I want to thank you very much, all the parents that indulged this teaching. And I hope I can be more, how can I say this, more approachable, because I did put in the link. But as I said, I know all these people are asleep. I mean, it's late night. I hope you all have a good night. And of course, I give all praises to the mighty Yahweh.